Good evening, everyone. Welcome to the Hillsborough Township special meeting of the Planning Board, July 20th, 2023. Please join me in a salute to the flag. Pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be advised this meeting has been duly advertised according to Section 5 of the Open Publics Meeting Act, Chapter 231, Public Law 1975, otherwise known as Sunshine Law. Notice of the 2023 annual meeting schedule and amended meeting dates have been provided to the officially designated newspapers, Township Clerk, posted on the Township's website, and available here at the Hillsborough Township Municipal Complex. In addition, application documents have been made available on the Township Civic Clerk website, and complete application files are available in the Planning and Zoning Department in accordance with the public meeting notice. And first, we actually have an oath of office that we need before we go to roll call. It's Patty Smith. Class 4 board members being appointed to seat number 9 from the alternate number 2 seat, as per the Township Committee resolution on July 18th of this year.
Raise your right hand, please. I state your name.
Patricia Smith.
Do solemnly swear
Do solemnly swear
that I will support the Constitution
that I will support the Constitution
of the United States
of the United States
and the state of New Jersey,
and the state of New Jersey,
and that I will bear true faith and allegiance
and I will be in true faith and allegiance
to the same
to the same
and to the governments established
and to the governments established
in the United States
in the United States
and in this state,
and in this state,
under the authority of the people,
under the authority of the people,
and that I will faithfully,
and that I will faithfully
impartially,
and impartially,
justly perform
justly perform
all the duties
all the duties
of the office of Class 4 member
of the office of Class 4 member
of the Planning Board,
of the Planning Board,
seat number 9,
seat number 9,
to the best of my ability,
to the best of my ability,
so help me God.
so help me God.
Congratulations.
Yeah.
So now you're really stuck, Pat.
No state of the board speech?
How long do you want?
Okay. May I have a roll call of board members and board and township professionals, please?
Let's see, Mr. Delcor, Mr. Scobo. That's it. Are absent, Ms. Smith? Ms. Smith?
Here.
Mr. Wagner?
Here.
Mr. Radowitz?
Here.
Committeeman Ciccarelli?
Here.
Mayor Lapani?
Present.
Vice Chair Julian?
Here.
Chair Sirachi?
Here.
Mr. Coys?
Here.
Ms. Bello?
Here.
Mr. Carr?
Here.
Mr. Bernstein?
Here,
Mr. Hay?
Here.
And myself and the videographer are here.
Mr. Lombardozzi, make sure the record indicates Mr. Peason is not here this evening.
Thank you.
Okay, thank you. Being this is a special meeting, it's an abbreviated agenda, so before we go to the application tonight, business from the floor for matters that are not on this evening's agenda. And again, please refrain from any discussion on warehouses, directly or indirectly, because we have many applications active at this point. We want to get those comments on the record. Okay, seeing none, now we will move to applications in the public hearing. Roycebrook Golf LLC.
Chairman, I would like to come forward.
Okay. Please state your name and record.
Maria Janusik, 720 East Freck Avenue,
5
Randall,
minutes.
New Jersey. I'm also a Hillsborough Township property owner, Block 86, Lot 3, 2155 Camp Lane Road. In regard to the recently adopted ordinance that forbids warehouses in the I-1, I-2, I-3 light industrial zone, in the LI light industrial zone, and then the GI industrial zone, have there been any applications submitted for a certificate of nonconformity from the property owners who currently have warehouses?
It's not an issue before the board at this time. You can ask the township for the answer to that.
It's not an issue before the board. This is the public portion right now for things that
The
are on
point
the
is,
agenda.
Mrs.
And this is
Janasek,
something
the board is unaware as to whether or not there are certifications of nonconformity or not, because in order for the board to be aware of certifications of nonconformity, they have to come before this board or the zoning board as part of the application. There's been no certificates before this board. There may be certificates of nonconformity, but this board is unaware of them. The proper place to go through is Mr. Coyce's office to ascertain whether or not such has occurred.
Oh, and Mr. Coyce is here, so it's very easy
Mr.
to
Coyce is here,
answer
but not in
questions.
his capacity as he's the planning board.
All I'm going to say is we have nothing on our agenda related to that matter.
Okay, are there any zones in Hillsborough right now that do allow warehouses as a permitted use?
Well, I think you just quoted the ordinance that basically made a clean sweep that is no longer an approved use, so any future applications will have to go before the zoning board.
I'm sorry, there's no zone at all in Hillsborough that now allows
Correct.
warehouses as permitted uses?
Correct.
Okay, can you tell me who, Ms. Smith, whose place she took on the board?
Mr. Hashtag had resigned from the board a few weeks ago.
Mr. Hashtag resigned. And what is a Class 4 member? I don't know the differences of the class member.
Class 1 member, according to law, is the mayor or designee.
I'm sorry, what?
The mayor or his or her designee. In this case, it's the mayor.
Oh, the mayor designated. All right, thank you very much.
Okay, thank you. Okay. So up is Roycebrook Golf LLC with file number 23-PB-04-RES with a time of decision of September 30th of this year. Okay, Mr. Lennis?
Yes, thank you very
Go ahead.
much, Mr. Chairman, members of the planning board. Turn on the green. Get a green light. Push it for green. It works. Okay, I'm live. I hope I'm alive. Okay. Okay, thank you very much, Mr. Chairman, members of the planning board, members of the public. I'm pleased to be here tonight on behalf of Roycebrook Golf LLC. I represent 3 planning boards, so I understand the nature of being a volunteer member of the planning board, and I could just see my planning board say, if I recommended a special meeting, especially in the middle of the summer, they'd look at me like I was in outer space. So my client wants me to thank you very much for giving us the privilege of your organizing a special meeting with a quorum so that we may proceed tonight. My first observation is that we did publish, we overpublished. We published both in the Hillsborough Beacon and the Courier News, and I did submit an affidavit of publication and service, so I would assume the board has jurisdiction.
Board has jurisdiction.
All right, thank you very much, Mr. Bernstein. Very simply, my client's application is to reestablish testing protocols that were established by the Planning Board's 1994 resolution. 1994, about 26 years ago, 30 years ago. Given the changed conditions at the property and in light of the upcoming sale of a portion of the property to Toll Brothers, we're here before the board to clarify and potentially modify and update certain conditions of the 1994 resolution. In the first instance, and by way of background, Roycebrook, my client, purchased the property from Hillsborough Golf Associates way back in 2007. I've been informed by my client that it had no prior knowledge of the 1994 resolution and didn't have any information relating from the resolution from the seller at that time. I looked at the deed. The deed is not a deed, it's not contained in any deed restriction, nor did the client have any information or receive any other information from the township regarding that. However, having said that, they're here tonight, and they recognize that they are responsible for either a continuation of the 1994 conditions or a modification. So they're not going away, and they've been around since 2021 when they first found out about the resolution and the conditions, and since that time, they've been actively sampling and sending in test results to the township. Unfortunately, none of us can turn back the clock relating to no samplings between 2007 and 2017, but what my client can do and will do is to continue to make sure to implement the 1994 resolution conditions wherever practicable and possible. And based on changed circumstances, there are, and you'll hear that from our expert witness, some of those conditions have to be modified or clarified. Since my client became involved with this project, there was a meeting with the Hillsborough Health Department to implement a plan to comply with the 1994 resolution. After several conferences with the township administration, the township attorney, and the planning board attorney, my client was advised that any update to the monitoring plan would require the planning board's approval. Therefore, we're here for that purpose, as my client's proposed testing moving forward accurately reflects the location of golf activities in relation to its neighbors' properties. Once again, Roycebrook takes full responsibility for moving forward in this matter, hoping to maintain, if not the letter of the 1994 conditions, the spirit of the 1994 conditions. We have one witness tonight that I will present. That's Dan Latanzi. He's an LSRP, and he'll explain to the board and the public what an LSRP is. And he serves as Roycebrook's environmental consultant. And he's here to discuss his March 8th, 2023 report, which has been on the website, as well as his June 28th, 2023 report, which is also on the website. He's ready to testify regarding his firm's involvement with the property. And that predates Roycebrook's involvement.
Frank. Stay close to the mic.
Thank you. And that predates Roycebrook's involvement. Dan Latanzi will tell you that he was initially retained by Toll Brothers to perform environmental services for them. So there is some consistency there in terms of Mr. Latanzi. And he's also, in his testimony, he'll address the staff reports that we did receive, the Environmental Commission report, Jocelyn Bellows' planning report, and Todd Hayes' report. I also have with me, although I don't plan to bring them up for formal testimony, Denny Miami. He's an owner of the, one of the owners of the golf course, and Matt Fauerbach, he's a representative for Troon, and that's Roycebrook's management company. So both will be available to answer any questions from the board and the public at the appropriate time. So without further ado, I'd like to introduce Dan Latanzi.
Mr. Chairman, while Mr. Latanzi is coming up, I'd like to make a couple of suggestions to the board as to how we address this going forward on several fronts. The planning department received on Monday another sampling report, et cetera, from Mr. Latanzi's firm regarding this application. The board also received the EC report on Tuesday, and I believe Mr. Hayes' report from Pannoni today. I have had conversations with Mr. Linus as well as representatives from Toll Brothers, and we have received the multiple emails from residents, or a resident on behalf of others in Claremont regarding the ability to make a request ostensibly for this meeting to be canceled because there is stuff up on Civic Clerk that is out of time. It is my recommendation that Mr. Latanzi testify as to those documents that were brought before this, that were submitted in a timely fashion. If he wishes to comment on Mr. Hayes' report and/or the Environmental Commission's report, he can. He can also reserve, and that he be brought back at a subsequent meeting to allow the proper time for the public, for the board, et cetera, to address the items that are, quote, out of time, close quote, for purposes of consideration. And that's my recommendation to the board as to this evening's hearing. Public can come up and question Mr. Latanzi related to that limited testimony, and they will have the opportunity, and we'll have to discuss that when we schedule another hearing.
Okay, that sounds reasonable.
Okay, I'd like,
Proceed.
before we have Mr. Latanzi testify, I do have some exhibits, and I'd like to pre-mark them
Okay,
so
should we
that the
swear
board
him in
has
first?
access to it.
We need to swear him in.
Mr. Linus, I'll ask them ask you a question. Has they been submitted at least 10 days in advance?
I believe so, everything other than Mr. Latanzi's curriculum vitae.
Well, I don't think that's necessarily an issue, but I would ask Mr. Coyce and Ms. Bello, as the exhibits are marked, to confirm that is in fact the case. And if you want them pre-marked, Mr. Lombardozzi is, I believe, still walking around with Exhibit No, not anymore. You just have to write on them then. Okay.
Okay, the first exhibit that I have and I'd like to mark it as A1, is a map. It's Figure 1 that was attached to the June 28th report that was submitted in a timely manner. And I have hard copies for board members, so I can distribute them tonight. Can I mark that A1 and date it today, Mr. Bernstein?
Please, Mr. Linus, provide the original copy to Mr. Coyce and copies of the reports to the board.
Great.
Okay, that's fine. I'm good. You don't have to tell me, whisper to me, you just place it on the record. Mr. Coyce, this is a document that's been previously provided in a timely fashion.
Yes, it is. It's a map that's at the end of the report that is dated July 17th.
No, then that is not a timely report.
Let me see. Actually, pardon me.
That was appended to the June 28th.
the same one?
I'm
All right,
waiting
let's
for him
go
to
back.
confirm it. I'm not disagreeing with you, Mr. Linus. I just want a confirmation. And mentioning the magic date is not the confirmation.
What's that other report? First. June 20th. Thank you. Yes.
Thank you,
Page
Mr.
15, June 28th.
June 28th, okay, thank
Yes.
you. All right, I'd like to pre-mark as A2 Mr. Latanzi's curriculum vitae.
That has obviously not been provided, but that's fine.
Thank you.
This is A2.
Is this one also? Is this on Civic Clerk? It is. And it should be noted that that is what Mr. Linus is providing, that is on Civic Clerk.
Anything else, Mr. Linus?
I have A3, which is a report dated March 29th.
Speak into the mic, Frank. Okay.
I have what I'm marking as A3, a report dated March 29, 2023, that was submitted with the original application.
Okay.
Mr. Coyce, Ms. BELLE?
Yes, that is something that we have. It was originally part of the application. It's in Civic Clerk, and it's one of the reports. It's dated March 29th.
Thank you. A3. Kill a few more trees. Anything else, Mr. Linus?
Yes. The June 28th, 2023 report, which has been on file for at least 10 days. I'd like to mark that as A4.
The entire report?
Yes.
A4.
Then I've got one more after that.
Is this with all attachments?
Yes, this is dated June 28th. It's on Civic Clerk, and it's something that we've had on file.
Okay.
And finally, a May 25th, 2023 letter authored by me, sent to the chairman of the Environmental Commission. And that's been on file for more than 10 days. I'd like to mark that as A5.
And the letter is asking for what? The report from the,
We'll discuss that in testimony.
you're testifying?
Just to confirm, this is something that we have on Civic Clerk and we have on file, dated May 25th.
Okay, and that's it for the exhibits that Mr. Latanzi will be testifying about.
I assume Mr. Latanzi is the A5. Mr. Linus will be testifying as the attachments to the letter and not the letter itself because it was authored by you.
The letter is authored by me.
Thank you. Mr. Chairman.
Okay. Now we're going to swear you in.
There we go.
Okay, Dan, you're going to be sworn in.
Just any testimony you give tonight is going to be the truth, the whole truth, and nothing but the truth.
Yes.
And for the record, can you spell your name, please?
Daniel, D-A-N-I-E-L, first name. Last name, Latanzi, L-A-T-T-A-N-Z-I. Thanks.
Dan, you want to give the planning board and the public the benefit
Frank.
of your educational and professional background and experience?
I thought someone spoke there. I'm good here. Yes, my name is Dan Latanzi. I'm a representative of First Environment. I'm what's called a licensed site remediation professional. I've been with First Environment since 2010, and I've been an LSRP since March of 2013. The role of a licensed site remediation professional is to guide and support remediations in New Jersey. Previously, prior to the enactment of the Site Remediation Reform Act, the department or the New Jersey Department of Environmental Protection oversaw and supervised remediations in New Jersey through a case manager. When that act went through and was finalized in May of 2012, they passed that requirement and that responsibility on to licensed professionals. So I am licensed since March 2013 and as LSRP and have been practicing since that time. I oversee small homeowner residential investigations to large multi-million-dollar cleanups in the state of New Jersey.
All right, and in that capacity, have you testified before boards of this nature?
Yes.
Okay. And have you been accepted as an expert in your dealings with boards?
I have.
Okay. I would move Mr. Latanzi's qualifications as an environmental expert.
Okay. Any gaps in your licensing?
None.
Okay. Any objections? Seeing none, we accept. Please continue.
All right, when did you first become involved with the subject property?
First Environment was retained to conduct due diligence of the subject property in 2017 on behalf of Toll Brothers.
Okay, and what did you do with respect to the due diligence?
We basically conducted what's called a Phase 1 environmental site assessment, which served to evaluate the current and historical operations of the property and to determine if there was any environmental conditions that would jeopardize the intended transaction of the property or purchase of the site.
Okay. And that was done in connection with the purchase and the development of the site, correct?
Correct.
Okay. And when did you first become retained by Roycebrook?
First Environment was retained in 2021, once Roycebrook learned of the 1994 resolution and the associated 1994 sampling plan.
Okay. Briefly, can you explain to the board and the public what efforts you made with respect to your engagement by Roycebrook?
Once we were engaged by Roycebrook, we obviously reviewed the required documents, the 94 resolution, and the corresponding sampling plan that was prepared by Equal Sciences to determine what sampling and what laboratory analysis was required pursuant to that resolution. Roycebrook was very motivated to begin the process. As you'll hear in my testimony, testing included the collection of groundwater samples and surface water samples for laboratory analysis to evaluate conditions as it pertains to the operation of the golf course.
Okay. All right. Did you prepare an expert's report dated March 29, 2023, which was part of the application process for Roycebrook?
Yes.
All right, and I think we've marked that as A3. All right, would you care to take the board and the public through that process?
Yes, the March 2023 report is a summary of the conditions that we are seeking to modify and or update. And it serves as a historical background of the testing that was prepared or performed by Roycebrook, as well as an outline of the 94 resolution and prior sampling that was conducted by Eagle Sciences.
Okay. And what does that report indicate?
That report indicated that there were certain conditions that were made in the 94 resolution that do not technically meet current standards as per DEP requirements, and we felt that they needed to be updated and modified. And as Frank said before, we were told that we had to come before the planning board to make certain modifications and or updates to those sampling plans so that we are more in line with the requirements of the 94 resolution.
Okay. Did you also prepare what we've previously marked as A4, the June 28, 2023 report?
Yes.
Okay, and very briefly, before you get into your main testimony,
Sure.
what does that contain?
That again contains a summary of prior testing that was performed by Eagle Sciences as well as First Environment since 2021. It also includes our intentions on behalf of Roycebrook as to what we feel is necessary to continue the monitoring of certain media, such as groundwater and surface water, as well as potable wells that are in the nearby residential area. It basically outlines, the testing, the requirements, the lab analysis, how many events we plan on performing, when and how we perform those tests, and provide an avenue for ensuring protection of the environment.
All right, Mr. Latanzi, you want to explain to the board and the public why we're here?
Sure. So what we're talking about here is somewhat technical in terms of environmental testing and reporting. The goals tonight of my testimony is to summarize the 1994 resolution as it pertains to the following conditions: Condition 9, 10, 13, and 8. We're going a little bit out of order in terms of numerical order, just to prepare my testimony here. The other thing is we're also going to provide, like I said before, an update as to what testing will be performed as part of the June 2023 testing plan. We're also going to present modifications and updates to the 94 resolution, and we're going to respond also to the Environmental Commission's comments that were made during the May 2023 meeting.
And you'll also testify with respect to the engineering report we received today, as well as the planner's report, which we received, I guess, the past week.
Yes.
Okay. Continue.
Okay, so I'm going to go through each condition one by one, and I think, to make it clear, I'm going to try to go slowly, going to try to tell you about some of the technical terms that we're going through, and we're also going to get into basically the history of each condition, what's the current status, and why we're proposing or not proposing a modification to each condition. So to start off, we're going to start with Condition 9, which is monitoring well installation and testing. Roycebrook Golf is seeking modification of Condition 9, specifically with respect to the monitoring well construction and associated testing. Condition 9 of the resolution and the associated 1994 monitoring plan require the installation of a monitoring well between the fairway of holes 13E and 16E. The proposed construction of the well was to a depth of 120 feet below grade, with casing or steel casing to 40 feet below grade and an open borehole from 40 to 120 feet. The purpose of the design was to, quote, mimic the majority of the wells in the Claremont subdivision. If you look at the exhibit, which I believe is A1, you'll see that the proposed well is MW6, that is near holes 13E and 16E, and to the east is the Claremont subdivision. Monitoring well MW6 was installed between the fairways of holes 13E and 16E. It was installed to a depth of 35 feet below grade and consists of 15 feet of solid PVC casing from surface grade to 35 feet. The slotted PV screen also extends 20 feet in total depth from 15 to 35 feet. The objective of the monitoring well, MW6, is to monitor bedrock groundwater for potential impacts associated with golf course operations. To clarify, this well, again, is installed in the bedrock formation. There is no actual water in the shallow zone or in the soil that lies above the bedrock. Therefore, this well is testing first water conditions below the site. The current construction of monitoring well MW6 performs this function in terms of monitoring groundwater more effectively than a proposed 120-foot well with an 80-foot open borehole, because a well that is installed to 120 feet with 80 feet of borehole will basically screen across multiple fractures in the bedrock and could potentially dilute concentrations that could potentially be in groundwater. Instead, the well that's currently installed acts to monitor first water conditions, and especially where you would expect to find any potential contaminants migrating from topical applications of the golf course into the groundwater. Furthermore, the proposed construction specifications of a 120-foot well do not conform to the DEP well construction and maintenance requirements. That's NJAC 7:9D. More specifically, the screen or open bore of a monitoring well cannot exceed 25 feet in length. While we understand why the 120-foot well may have been proposed to mimic the wells of the Claremont subdivision, it's not technically feasible to install a well of this construction, and it goes against DEP requirements.
And that monitoring well was never installed, correct?
That's correct. Based on the multiple lines of evidence presented herein, a modification to the monitoring well construction and the specifications is being requested. The 1994 monitoring plan required the collection and analysis of a groundwater sample from the monitoring well location in June and October. So once you install the well, it's able to produce water. We're able to collect the sample. We then transfer that sample into appropriate glassware. It's submitted to a laboratory for analysis. And any lab we work with has been approved by the DEP and is registered with the state to perform said analysis. As part of the updated sampling plan, Royce Brook proposes to continue with the monitoring events that we have been performing since 2021. To date, groundwater monitoring has occurred in 2021 and 2022, and the corresponding results have shown no exceedances to the DEP's groundwater quality standards. Additional testing will continue in 2023, 2024, and 2025. If there are no exceedances to the DEP groundwater quality standards for these compounds that may be associated with the golf course operations, the sampling will be discontinued, since a total of 10 sets of data will be available to show that there's no impact to the environment. Typically, when we're conducting remediation on sites for the DEP, they require 2 confirmatory events over a sample 90 days apart. So if you say you had some kind of issue and it's been cleaned up or remediated, and you sample and it comes back below standard, you would return 90 days to confirm that finding, and you can close out a case. For this purposes of this sampling plan, like I said, we'll have 10 total data sets or quarterly events to show that there's no impact to the environment. Given that this is a different protocol for sampling, Royce Brook is requesting a modification to the monitor well sampling plan, since it differs from the 1994 sampling plan prepared by Equal Sciences. Okay. Frank, would you like me to stop at each condition, or do you want me to keep going?
Keep going.
Sure. Okay. So a lot of technical information, like I said, but we're rolling through here. Condition 13 is for a requirement to collect surface water samples, as you'll see on the map, or in Exhibit A1. There are certain waterways that are on and adjacent to the property, including the Millstone River to the east and the Claremont Pond directly to the east-southeast of MW6. Royce Brook Golf LLC is seeking a modification of Condition 13, specifically with respect to the collection and analysis of surface water samples. Condition 13 of the resolution and the 1994 monitoring plan require the collection and analysis of 1 surface water sample from the location where the stream leaves the golf course towards the Claremont Pond. If you look at Exhibit A1, you'll see surface water SW1. That's on the boundary of the property. Thank you so much. And then to the northeast is the Claremont Pond. So the purpose of that, the intention of the 94 monitoring plan was to collect a sample at this location to see if there's any contribution from the golf course operations on that water body. Sampling was to be performed in June and October of each year. Analytical results are then compared to the DEP surface water quality standards. In addition, while not currently required by the resolution and/or the 1994 monitoring plan, surface water sample SW2 was periodically collected by First Environment from the drainage way that traverses the northeastern corner of the site. If you could just scroll up for me on that exhibit. Thank you so much. To the top of the page. Thank you. So, like I said, there's SW2. Again, First Environment collected this sample periodically, and it's a drainage way that traverses the northeast corner of the site, which flows below Millstone River Road towards the Millstone River. Analytical results collected to date by First Environment showed that there were no compounds that were above the DEP's surface water quality standards. As part of the June 2023 sampling plan, First Environment proposes to continue to collect a surface water sample from this location, SW2, in June and October, and submit the results for the same laboratory parameters as in the 1994 monitoring plan. Since this sample location is not included as part of the 94 monitoring plan and Condition 13 of the resolution, a modification to Condition 13 as it relates to the number of surface water samples to be collected and analyzed is being requested. So again, we're looking to add SW2 to our sampling plan. To date, again, surface water monitoring has occurred in 2021 and 2022, and the corresponding results have shown no exceedances to the DEP surface water quality standards with respect to golf course operations. Additional testing will continue in calendar years 2023, 2024, and 2025. Similar to the groundwater testing, after a total of 10 data sets have been collected that show no impact to the environment, surface water sampling will cease. As such, a modification to the surface water sampling plan is being requested, given that only a certain number of samples will be collected, and then we'll stop after a certain time. All of the sampling plan here is supported through DEP requirements and will ensure the protection of the environment. Condition 10, while noted, moving on to Condition 10, while noted here today, there are no modifications or updates to Condition 10, and I feel like, Frank, we can move on from 10. There's we're not sure why it made the meeting, but Condition 10 again is
no change.
No change. There's no change, so we're going to move on from it. The last condition is Condition 8, which is potable well baseline testing. Condition 8 of the resolution required the collection and analysis of potable well samples from residents located on Ann Street or Hamilton Road, which are located to the east of the site. The purpose of the sampling and testing was to establish a baseline groundwater condition within the potable wells prior to the commencement of the golf course operations. Condition 8 of the resolution did not require any further testing beyond the initial baseline sampling event. The test was performed by Ecosciences, and the results included as part of their off-site potable well water quality testing report dated August 8, 1996. Later on in my testimony, I will say that the Environmental Commission requested a copy of this report, and it will be made to the Environmental Commission and to the Board upon request. The results of that test confirmed that all analytical parameters required to be tested under the resolution, which are also included as part of the Ecoscience 1994 monitoring plan, were either not detected or detected at concentrations below the DEP's drinking water quality standards. The only exception was that fecal coliform was detected in a sample collected from the residents at 251 Hamilton Road. Based on these results, and since the testing was performed prior to the start of the golf course operations, the presence of fecal coliform in the sample collected from that residence, 251 Hamilton, is not associated with the golf course, but is instead attributed to ambient conditions. Basically, again, the sample.
And that was the only exceedance.
Correct, yes. I wouldn't, it was a detection of fecal coliform, so again, it was collected prior to golf course operations and therefore considered, I wouldn't say naturally occurring, but ambient to the groundwater conditions of that home. Based on the foregoing, the results and the requirements outlined under Condition 8 have been met, again, just to establish a baseline for those potable wells. From a DEP perspective, when I deal with remediation sites, testing of potable wells only occurs typically if you have contaminants on the property. So if you have something of concern, you begin to do what's called a receptor evaluation. You look outward. You want to see if any potential the public or human health are going to be impacted, such as potable wells, and you step out from there. We don't have that here. We have done several tests. We don't have exceedances in groundwater testing that would warrant further step out of potable well testing. But again, we've already met the conditions of Condition 8, and we're not requesting any modification to that condition.
Okay.
So that's, Frank, that is all for the conditions. I could also now respond to the environmental
Before we
commission's
get to your next portion of testimony, is it your professional opinion that A5, which is the June 28th report, will serve to be an amendment to the groundwater and surface water plan?
Yes,
Okay. And do you think that, based on all the circumstances, that that's an adequate replacement?
I do.
Do you think in certain instances it's a superior replacement?
Well, I feel like we've added a few items to the tests, specifically with respect to the surface water sampling. And while the change in monitoring well, in terms of its depth, may differ from what EcoScience has proposed, we feel that it more accurately characterizes groundwater conditions and potential contributions, if any, from the golf course operations. So we do feel like it's an improvement.
And that's based primarily on changed circumstances, DEP regulations, et cetera?
Correct.
Okay. You attended with me and our client the May 22nd, 2023 meeting of the Environmental Commission, did you not?
I did.
Okay, and the Environmental Commission issued a report, and did you have an opportunity to review that report?
I did.
You want to make your comments or answer any questions that were raised in that report?
Sure. There are a total number of 5 questions, comments that the Environmental Commission made in their memo dated July 18th, 2023. I'm going to read off.
That's the date of the Environmental Commission memorandum.
Correct, of their memo. I'm going to read off their question and comment, and then I'm going to respond in kind to each comment. Comment number 1, the Environmental Commission requests a copy of all sampling results referenced in said letter dated March 29th, 2023. To date, Hillsborough has been provided with all sampling results and all reports that were prepared by First Environment on behalf of Roycebrook.
So it's already been submitted?
It has been, but we will, for completeness, we will submit the reports again directly to the Environmental Commission so that they could check the box there on that. Comment number 2 is a clarification on the March 29th, 2023 report that was prepared by First Environment. The comment is, quote, "The results of the testing confirmed that the initial application of materials did not affect drinking water or surface water conditions as analytical parameters remained at concentrations below DEP thresholds." The Environmental Commission states that this is a misleading statement, as the purpose of the initial testing at the residence was to establish a baseline prior to the application of materials at the golf course. This test was not conducted after the application of materials, and therefore this is a misleading statement. Drinking water was not affected by operations. As such, the statement needs clarification and correction by Roycebrook. So to clarify that, again, the Environmental Commission's asking me to clarify that statement. The samples were collected, again, prior to golf course operations and served as a baseline for groundwater and surface water quality. So the statement that was made in the March 29th, 2020 report was slightly misleading, but again, the intention was to show that the testing was performed in accordance with the 1994 resolution.
So I want to be clear on that. The testing occurred prior to the operation of the golf course?
That's correct.
All right, continue.
Another question, comment was sample 251 Hamilton Road for fecal coliform, if possible. As previously noted in my testimony, the initial testing was performed prior to golf course operations and served as a baseline. The detection of fecal coliform, therefore, is not representative of the operation of the golf course, but is more likely a condition of ambient conditions. Any further request for testing of potable wells will be responded to by counsel for Roycebrook. Next comment, Roycebrook to obtain baseline results of residential potable well samples in 1996. Like I said before in my testimony, we have the results from EcoScience, who did the testing on behalf of the township and actually in concert with the Township's Board of Health. The date of that report is August 8th, 1996. We will provide a copy of that report to the Environmental Commission. The next question comment is Roycebrook to obtain and provide results of reference 50-plus soil samples that were collected for pesticide analysis. During this meeting, we discussed First Environment's involvement with the due diligence, with Toll's due diligence of the property, and we felt that it was necessary to evaluate soil conditions of the property given its use as a golf course, and also potentially because of the historically applied pesticides that may have been used when it was farmland. If you could bring up Exhibit A2. Should be the next figure down.
No, you mean
Please.
figure 2.
Or
Figure 2. A2 is your
Where's
curriculum
night?
vitae.
Where's the? There it is, right there. What number is that? Sorry, Frank.
It's okay. That's figure A2, which was attached to your June 28th report, correct?
So yes, correct. Kind of difficult to see here, but the yellow line represents the proposed subdivision at the time. I believe that's still accurate, of the golf course. And those little dots you see, thank you for zooming in, those are soil borings that we installed. We installed 54 soil borings at locations that would be biased to where you would expect to find pesticides or herbicides to be found. Samples were collected, submitted to a laboratory for analysis. All work was done in accordance with DEP requirements. Again, those samples were collected and submitted to a laboratory. Of the 54 samples, they were tested for pesticides, arsenic, and lead, and the findings of the investigation did not reveal that no samples were above DEP thresholds. The results further showed that the golf course operations at this time do not impact soil quality at the site. The last question is respect to the 94 resolution and the sampling of 19 residences. Based on the information presented regarding the history of this water sampling issue, the February 1994 resolution and its requirements contained therein, and public comment, the Environmental Commission recommends that the portal wells for 19 residences initially sampled as part of the baseline effort in 1996 in accordance with the 94 resolution be resampled to determine current conditions of these portal wells due to the fact that the nearby monitoring well MW6 had not been biannually sampled by the golf course operators since golf operations commenced as required by the 94 resolution. The Environmental Commission also recommends this resampling of the 19 residential portable wells in Claremont neighborhood be done in partnership with Roycebrook and the Township of Hillsborough. Resampling of the 19 residential portable wells is the only way to determine their current water quality condition in light of MW6 not being sampled as required by the 1994 resolution for 20-plus years. End of comment question. It should be noted that while 19, this is me now speaking, it should be noting that while 19 residents were supposed to be sampled, only 16 samples were collected from residential homes. It's assumed that both the township and Eco Sciences had an issue with gaining access to the 3 other residences. Notwithstanding that, any recommendations for future testing for potable wells is now being taken under advisement and will be reviewed by Roycebrook.
Okay, did you concluded your testimony?
Yes.
In that phase of this testimony? Okay, did you have an opportunity to review the July 20th, 2023 report issued by the board engineer, Todd Hay?
Yes.
Okay, you want to provide your comments?
Yes.
Or response?
Yes, I had a chance to review the engineer's report dated July 20th, 2023. Again, it goes over some of the similar things that I just mentioned in my testimony, a history of the 94 resolution, and it also makes certain recommendations as to what the engineer feels should be done at the site, specifically with respect to the extension of a well that would be installed to 120 feet, or an additional well that should be installed to a depth of 120 feet. And again, given what I said in my testimony, we feel that the monitoring well that's currently installed, MW6, functions properly and is installed in accordance with DEP regulations to evaluate potential impacts from golf course operations. You have to understand that things are being applied to the surface, right, to manicure the golf course. We did the testing of the soil. There's nothing been detected in soil that's above DEP standards. There's then several feet of soil that separates the top of the ground to the rock, and then somewhere between 15 to 35 feet is a fracture that produces water that allows us to collect a sample. Any potential contaminants would be found in that first water-bearing fracture, just through vertical migration. However, also, we know we're dealing with pesticides and herbicides here that don't really readily leach into groundwater. So we feel that, again, this well that we have installed is appropriate and that the need for a deeper well is not warranted at this time.
Okay.
Go ahead, Frank. I was going to say there's other comments, but we're not yet prepared to comment on some of these other requests or suggestions for review by the boards or by the township's engineer.
Okay. I have no further questions of Mr. Latanzi.
Mr. Attorney?
Mr. Chairman, if I may, thank you very much. I appreciate it, board members. Yes, we did prepare a letter today outlining our comments and our review. Keep in mind that the review also took into account the EC's comments as well that were provided this week. We wanted to look at those in conjunction with some of the historical data and the conditions that were found in the 1994 resolution of approval. I understand, what the concern is from, reading some of what was done in 1994 from both the Eagle Sciences report, the First Environment report. I think that there's some optics, and I did have my licensed site remediation professional review this specifically to give me some ideas of what we can do to ensure that we don't have an issue with the public. I mean, our role as the engineer here is to make sure that the public's being protected and the board's being protected. That's really what it comes down to. So some of it could be considered and constrained as optics, but at the same point, we need to make sure we eliminate the possibility that there is any type of migrants that have, or contaminants have gotten migrated into the fractured rock, and we are recommending that that well be done. Now, I did hear the testimony of the applicant's LSRP. If there is no technically feasible way, or no way that the DEP would provide for a permit, which they have to get to drill that deep, then that's totally understood and what have you. And I think that that should then be reiterated and fully evaluated and discussed at the next hearing, whenever that hearing is going to be. But we believe that, in talking to my environmental folks, that we should, go ahead and go at the caution of error, look at and make sure that the public's being protected. And if something is found, that might be able to be determined and determined way in advance of another hearing, so that we could educate the public as well as the applicant's LSRP could educate the public. So I think there's a safeguard there. There are some optics, but I think we need to have a safeguard, and I think that's extremely important to note to the board. This is about protecting the public. This is nothing more. And we understand that in order for this applicant to move forward, they have to fulfill these obligations. So, again, looking at it from that perspective, I asked the board to think about that, contemplate it, and deliberate it. But this, we've taken into consideration what the LSRP has said, but in looking at the data, we want to be absolutely sure. The other thing I will mention, Mr. Chairman, that was not mentioned in testimony, but I think it's important to note is that there were comments at the EC meeting originally, and there were comments that were put into the record as to, whether or not testing needed to be done on Ann Street to the east of the property to ensure that there was no issues with the 19 homes. We recommend in our report, and as you've noted, that because there is no historical sampling that's been done, we believe, again, we want to protect the public here, and we want to make sure that there's not issues in terms of any type of contaminants. We believe that the fecal coliform reading in the monitoring well number 6 also warrants this testing to be done again. The testing could probably be done in the next few months, and those results could be shared with us. And I would suggest that if the board determines that this is the direction that the board wants the applicant to follow, that we would work with the applicant to look at the results to make sure that the results, again, we're protecting the public and we're educating the board and we're educating the public as well at the proper time. The sampling data that also from 2021 to the most recent sampling data, we found some data gaps and what have you, and we want to look at those data gaps. I think the applicant could probably provide those to us. We could look at those further. And I mean, some of those issues, I think we could, get beyond and move on, because as you see in the last 3 bullet points of our report, we found some issues with respect to exceedances that we feel that needs to be looked at further. And if these exceedances can be mitigated or if they can be explained, then I think we need, we have to explain that to the board so the board can make a educated, rational decision, and we have to educate and explain it to the public so that they know what the outcome is and what the mitigation is going to be. I will also mention that we did note that we'd like to see the phase 1 and potential phase 2 that was done for the septic system, and we're also asking that, and that is also one of our recommendations in our memo today. I just want to make sure the board notes, and I think the public needs to hear this, we are here to make sure that there is not going to be a public health safety threat, and that's what we're here to do. So those are my comments, Mr. Chairman. I welcome any questions from the board.
Okay, thank you. Board members?
With the chair's permission, I think Mr. Lattanzi would like to reply to some of the comments.
I did have a question. Where would you think the well, this new well would be? Would it be in the vicinity of MW6? Or?
We said it would be in the vicinity. You have to understand, to get a permit, you're going to have to be within a certain proximity, what have you. I've drilled wells before, especially deep water wells, and again, it may not be technically feasible to do that, but we need to know that that can be done or not. I mean, to say it's not technically feasible, well, go ahead and do the well, and let's go ahead and see what the results are. If you can't get to a permit, then, well, okay, then that's a different story. But I believe in talking to my team that it can be done. It's got to be done within proximity, and we need to look at what those results are.
Okay, thank you.
Thank you.
I have just a question for the LSRP, and if you could maybe, for those who aren't LSRPs, and when you do water sampling, are you taking one sample and testing, or are you taking several samples, doing the same test to make sure that there's no delta between the results? And then on your water, I guess the surface water, is it really just pulling water off the surface? Is that generally that's what it is? It's right what's flowing across the top of the ground?
Yes, well, for surface water, correct. You're going to a set point, and it's obviously surface water is not stagnant, right? It's going to be moving, so you're collecting it at a certain point each time. It could obviously change given rain events or given a dry spout. Yes, you're right. We take basically a glorified extended stick with a cup at the end that's properly decontaminated. You reach into the stream, you collect it, you put it into a laboratory supplied glassware. It's simple as that. For the groundwater, we're only taking one sample for the well. The process is you purge the well of the water, okay? If you evacuate the water, it's bringing fresh water and actual groundwater into the well through the fractures in the bedrock, okay? Now you have water that's fresh and it's all there in the casing of the well. We collect the sample with a baler. Again, we transfer it to glassware and send it to the laboratory. But it's a uniform sample. There's no need to collect samples at multiple depths because the DEP regards that as basically one consistent and cohesive sample in the well.
And once that sample is taken, what is the timeline from when you receive it till when it gets to a lab and begins testing? A day, a week?
They have certain holding times, like certain parameters, like the lab has to analyze. Some are immediate, some are within 4 hours or 8 hours, some are within 14 days usually. But, we submit it to the lab under a chain of custody, right? We have all of our sample analysis and our naming on there. It's signed off by our staff, it's then signed off by the laboratory, and they begin normally right away, or they basically have to just stay within the hold times that the EPA require and the DEP require. So it's really up to the lab's discretion as to when they start running the samples.
And my last question, if the lab should find something that is out of spec, are their report to you and it's your responsibility to report to, say, the DEP, or does it go from the DEP, they send it right to the DEP if there was some kind of issue that they found?
It comes back to us, and then we discuss it with either the lab director or their chemist to determine what's going on with the sample. If there was something that was out of range or was out of calibration in their instrument, or, for instance, if this can happen sometimes, not that it's happened here, but like we said about the holding times, if the holding time was exceeded, or sometimes if the cooler temperature is off, the lab presents us, it's called a non-conformance summary. They put those non-conformances in the lab report to us. The LSRP then reviews it and then discusses with the lab corrective actions and whether the data is usable. You go through this evaluation. So again, if there was an issue, we simply would go back out and recollect
So
and
that
analyzing
is
it.
your primary responsibility to make sure it's done
Correct, and yeah,
correctly.
in accordance with the DEP requirements.
Okay, that's all I have.
Okay. Was there anything you want to comment back to Mr. Hayes?
Yes, we do have a Phase 1 report that was prepared some time ago, and it goes into the history. I don't believe it discusses the septic systems as an issue. As you may know, the septic systems are under an Egyptes permit, and they're monitored, and they have a DEP case manager who we've talked about with that. And the DEP understands, too, that once redevelopment occurs, the septic system will be decommissioned and the wells also removed by a driller. So if you need, looking forward to working with you on some of these things. We'll try to get you the information you need to make some of the calls, and we'll certainly be discussing the technical merits of installing a deeper well compared to, what's going on currently at the golf course and what may be occurring at the neighboring residents. So, looking forward to hearing your thoughts and the technical opinion of your experts, and I'm sure we can come to some sort of conclusion as to how to proceed.
Mr. Chairman, and that's, again, it's kind of what I was alluding to before. We get these results. We'll work with the applicants, LSRP, to look at and make sure that we have proper closure, so when we come back, we can have a proper explanation for the board and for the public.
Okay. Mr. Boyce? Anything from you guys?
Nothing at this time.
Okay. All right, so we'll open the public now. Mr. Bernstein, you'll reserve as always.
Can I ask a procedural question? There's a discussion about the initial baseline results being provided, and I would think that those should come to us, right? I mean, the Environmental Commission serves its role, but if there's a report coming, it should come to the Planning Board, not the Environmental Commission.
That is correct.
Thank you.
And Mr. Chairman, I'm not an attorney, because I don't want to overstep Mr. Bernstein, or he'll kick me in the pants. He knows he will. But the fact is, the results would come directly to us. We will share those results with the EC. I mean, their comments we took their comments into account with this report. And it's good we caught it early so that we can, look at that. And we looked at the residents' comments as well. And again, some of this is optics. I want to stress that to the board. But we have a role for public health and safety. We have to do what we have to do, not only his role as a planning board engineer, but also as township engineer.
I agree. Okay. Motion to open the public.
So moved. Second.
Okay, all in favor? Aye. Okay, if there's anyone from the public that would like to question this witness on his testimony, please come up to the mic, state your name and address for the record, please. Okay. Do not see anybody. Mr. Byrne? Oh, we got a last minute.
Sorry for the delay. Tom O'Donnell, 33 Ann Street. This is for questions for the witness, right?
Correct.
To the testimony given. So, one of the items discussed was the 120-foot well. And the witness commented that if they went deeper, that it potentially would be sampling multiple fractures and diluting the sample. The question I have is, since our water is down 100 feet, I understand testing above, I get the concept, but I've read the 1994 resolution several times, and I think it was designed to replicate a house and what we have. I know exactly what's in my property. It's a 120-foot well, 80-foot casement.
Right.
My water is at 90 feet, and my pump is sitting at 110. So you want to test at 35 foot, but we're in a very fractured environment, right? It has a lot of bedrock. And I read some of the comments from the EC, and were consistent with our concerns, that because it's fractured, you said vertical, what was the word used?
Migration.
Vertical migration if it is highly fractured, couldn't it vertically migrate below the 35-foot and not be showing at the 35-foot level? And wouldn't you be able to counter your statement that's saying you would be testing multiple fractures? I personally would like to test multiple fractures to get more samples, to see if there is any chance of contamination, versus saying, well, I only want to test one fracture. Like, let's get more with the testing to be more, to your point, to be more safety conscious and more effective. So that was the first thing I had. Let's see.
Do you want to respond to that? Is that a question?
That's my first question.
It's always so difficult here. You're behind me, and I want to look at you, but I want
Yeah,
to
it's
I want to
okay.
talk to the mic. You got maybe put the live feed on there so I could look at you through the back. But I understand what you're saying. Like I said in my testimony, the 120-foot well was designed to mimic the wells that are in the subdivision, and we get that. We get why that was proposed, but simply put, that type of monitoring well is not, it doesn't really correspond to the regulations that the DEP has for a monitoring well. Of course, it applies to a potable well. For a potable well, you're trying to go across several fractures so that you have enough water to supply your home, but that's not the purpose of a monitoring well. For us, for the DEP, you're always looking to characterize where you would expect to find contaminants at the highest concentration, given the topical applications at the golf course. Everything's happening at the ground, right? And then if perchance something happened to percolate downward through the soil and get into the rock, you want to capture it right there where it's going to be in that first water-bearing fracture. You're basically biasing your sample to where you would expect to find something. Let me also say something about pesticides. They don't readily leach into groundwater. They're technically immobile, or they're being characterized as immobile by the department. So again, even if they're in the soil, which again, with our testing up there that you see, we did 54 sampling events around the golf course, biased to where you'd expect to find the most heavily treated areas for pesticides and herbicides, we didn't find anything in the soil. So when you talk about, we just said about vertical migration or following a discharge, right? You'd have to have it in soil, then have to migrate through that soil, and then it'd have to get into the groundwater. Okay, but now we're talking about a compound that does not readily leach into groundwater. So we feel that the 35-foot well accurately characterizes groundwater conditions and better defines what the department would require in terms of a groundwater investigation compared to what the 1994 resolution said.
So is it basically a regulatory issue?
Yes. It's regulatory from a perspective. You cannot put in a well that has 80 feet of borehole, and it's technical because, again, we're assessing where we feel any potential contamination would be found.
All right, I have a couple questions based on that comment. Oh yeah, I have a few questions. It's not set for my height. But. All right, I have a couple additional questions. The 50. Thank you.
Me too. Do you mind holding?
I know.
I feel like I should sit on the other side.
Better? Okay, so the 50 places that you're sampling for ground contamination, what are those wells?
Soil borings, correct.
What's the depth of those?
Those are from the top 6 inches of soil. So from the surface down 6 inches in.
6 inches.
Right, that's the required depth for a sample. When you collect a sample for soil, it has to be on a 6-inch interval. So if we're collecting it from the top of the ground surface, you're collecting it from 0 to 6, from usually a 1-inch diameter boring, and you use that to then transfer the soil into glassware to collect the sample.
So my question is, based on my calculations, we've had 400 tests not conducted in nearly 30 years, according to the 94 regulation. And this land has been fertilized for many, many years. So you're saying that you're only testing 6 inches. My common sense tells me that there's a chance that it's gone deeper than 6 inches. And then my follow-up question to the possibility of there being contamination below 6 inches because of the term, what is the impact when you are going to disturb all of this land to dig out all these buildings and put basements in there? And have you looked at, personally, the structure of our soil and the amount of shale and fragmentation and the bedrock that's in it?
No, that's not really part of my testimony about what's going to happen with the property when it's going to be redeveloped. I have to assume that the subdivision or the redevelopment will be subject to a soil erosion and sediment control plan that would be approved by the county, and that would have to be followed to mitigate any runoff of soil or sediment during excavation, if I assume excavation or grading would be necessary to develop the property. But that's in my some of my experience on similar cases. A developer will then, again, rely on the soil erosion and sediment control plan to mitigate any potential impacts to neighboring receptors. Another comment about the soil, a majority of the samples were collected from 0 to 6 inches. A few samples were collected deeper, just as to establish a baseline for soil conditions. Also, because the property was used potentially for farmland, there was potential for historically applied pesticides, so we collected samples from approximately 2.5 to 3 feet, while I'd say only about a fifth of the samples were collected deeper. Majority were collected from that 0 to 6 inch interval, again, to evaluate the golf course operations.
I'd like to suggest that that information also be available to the planning board and the EC where deeper samples have been taken.
Sure.
I'm also very interested as to why there are no samples taken from where basically all of the water that potentially is carrying all of the chemicals in where your SW1 well is being drilled. Why are there no boring samples in that area?
Could we go back to, I think it's, if you go up. Okay, so MW6 is the monitoring well. SW1 is a surface water sample location. Are you
Yep.
are you saying that the well should be put in a different location?
No.
Okay.
What I'm saying is, why haven't you taken any 6-inch bore samples in the area where the majority of the flow of the water that potentially is taking the any chemicals or contaminants towards that area? Why aren't there any bore samples around that south SW1 well? They're all up in the north, up by the train tracks.
Okay, I can see where you're saying, but also that's the function of SW1 is to evaluate potential contribution from the golf course as it migrates off-site into the pond. So that's, SW1 is a surface water sample, so it would pick up anything that's coming from the golf course.
When you're testing it. But is it possible that the surface water is not being tested for between the 6 months, that it's now going to migrate topically down into the soil, into that top 6 inches?
Well, I don't think stated in the monitoring plan or in the resolution. It seems to me that because sampling is performed in June and October, you're biasing your sampling events towards when the golf course would be active, right? When they'd be actually applying topical applications of pesticides or herbicides to the ground. So that's why, the sampling is done during those periods of time. We can't speak to why there would be different tests at different times, but that's really, you're trying to, again, bias your sampling towards the time and the locations where you'd expect to find something. That's what we're doing in accordance with the 94 resolution.
Okay, follow-up question to that statement. You're saying that the pesticides are more heavily put into the ground on the golf course during those times?
I don't say heavily, but I would say I'd have to assume that that's when they're used.
Okay, because I live behind this golf course, and
Okay.
I know when they spray.
Okay.
And they spray in the January, February timeframe. Okay, so I want to know if there's a correlation to your testing to when these pesticides are being sprayed.
Again, the 94 resolution contemplated testing in June and October, and I'm surmising that that's why they picked those dates, because of when the applications would likely be at their most, based on the season and the operation.
If that's the case, that's great. I mean, I love Mr. Hayes' comment that the job of the board here is to protect us as a neighboring homeowner. I'd like to know that if we can improve the 94 resolution to have the testing done at a better time, given how the actual golf course is operating, I would say this is the time to do that. So next question. One of the comments made during the EC meeting was regarding the use of the river to irrigate the golf course and taking water out of the river when the water level is very low. And there are, I forget what he said, but there are contaminants that are in the water that are basically being sucked up, put on the golf course, and then coming down through the surface water. Is the golf course aware, and I think the township is aware, of the major fish kill that we had last year? In years past, it was always suspected to be our septics. Well, our septics are now not an issue. We lost all of our fish in our major pond. And, you know, I know we're not doing the testing. It would be nice to have the testing in place, but that's even more reason to have the testing running. Is there any provisions for this project to look at that water coming out of the river?
Well, the 94, out of the river, we have if you scroll up on the map, we added the surface water sample 2. That was not originally contemplated in the 94 resolution. We started, under Royce Brooks' direction, we started testing that on our own. We started making that evaluation way before we ever met with the Environmental Commission. We've tested that at least that location 2 to 3 times, and we're adding it to our sampling plan, again, to show that if there's any potential impact from the golf course as it migrates towards the Millstone River.
Okay, and next question is related to a letter that I sent to the planning board. We recently had a visitor in our community that was unannounced and turned out that he was doing surveying. Was his surveys for our stormwater capacity in our community part of this discussion here or part of the preparation for this discussion? We're trying to figure out what that was about.
Is that a question for me or for the board?
Maybe both. I'm not sure.
It's going to be for you because it's
Sure.
what that time
It was
is.
not. Yeah, that survey was not part of any of our environmental testing or review.
Okay.
Our being First Environment and Royce Brook.
Right. Thank you.
Sure.
Just want to make sure I get everything I copy here. Oh, yeah, you use interesting words. You use the word remediation and following the guidelines for remediation. I thought this was proactive monitoring. And at one point in your testimony, you said you were consistent with the remediation requirements.
Mm-hmm.
Are we remediating something here that we don't know about? I mean, you implied that, Mr. Hay, that there's some readings or something that was out of line. So are we in a remediation situation?
No. I guess I use the term remediation globally because the department has what's called the technical requirements for site remediation. Site remediation encompasses multiple different phases. It goes from a simple preliminary assessment, which is analogous to a phase 1 that you may have on a property where you're just doing desktop review and reporting on a history of a site, similar to what we prepared early on for the due diligence of the property, all the way up to active remediation, where you may be excavating, you may be trying to pump or treat different contaminants, and also through sampling. That's called a remedial action. Again, it's just kind of an all-encompassing word in terms of remediation. But to answer your question, like I said, there's no ongoing remediation here. It's simply just monitoring.
Okay, so that ties into my comment that I can just speak loudly. This ties into your comment that you're only going to test to 2025 because that's the requirement for remediation.
Sorry, we have someone, a recording secretary that has to hear this, so it's important he gets on the record. Here you go.
Okay, thank you. You commented that you would stop in 2025 because that would satisfy the remediation requirement. And if we're not in a remediation, this is an ongoing monitoring, which was the intent of the 1994 resolution. Why should you stop in 2025?
Well, part of remediation is monitoring too. You know, when you have say you had contaminants that were above a certain threshold, you're required to monitor them. And once they fall below, like I said in my testimony, you collect 2 confirmatory rounds, and after 2 rounds, you're done. The state realizes that, if you have data to support that the environment's not being impacted, you can move on. So what we're proposing is we're going to have at the end of 2025, 10 total data sets of results to look at to show clearly that the golf course operation is not impacting the environment. Now, if those results somehow change, or over those 10 years, over those 10 data sets, something changes in our review, of course, we're going to evaluate it and make the proper determination going forward. But we felt that, like I said, given that usually it's only 2 events that shows that you're clean, and we're going to have 10, we felt that was an appropriate plan for future sampling.
So the essence of the 94 resolution, does the 94 resolution have a cap on its testing?
No.
But you want to cap the new testing?
David, it's off.
Yeah, you just have to, I think you just have to be a little careful about where your fingers are.
I am, I'm making sure I don't hit it.
Okay, let's try this one.
You got it.
Thank you.
I'll make sure.
Thank you.
Again, there we go. So the 94 resolution had no cap. We don't have 400 sample testings that we should have, but you want to stop after having 10. I don't think that satisfies the essence of the 94 resolution.
Okay, that's your opinion. Are you asking me a question?
Do you think it equates?
I do.
Can you explain that?
Like I just explained that before, where I feel that, again, the 94 resolution, there has been a lot of changes in regulations over the years. We're talking about 1994. For instance, the instance with the monitoring well and the construction of the monitoring well, that's outdated. I can't speak to exactly what they contemplated in the 94 resolution and Eco Sciences monitoring plan, but all I could say from my experience on other sites, similar to this, that, collecting that amount of data over that amount of time, again, sufficiently shows that there'll be no impact to the environment. I do feel like that it's technically appropriate.
Mr. Chairman, you mind if I could jump in here for a second, just so I can make sure?
Can I suggest that Mr. Hay reserve his comments?
Till the end.
Thank you.
I'd like to comment on this after this, just on that particular point. Thank you.
Yes.
Thank you. The next comment I have, there was a significant amount of testing around the septic system. I believe there was going to be 8 test wells around the septic system according to 94 resolution. And I understand that septics will go away, which is a good thing, but are they being tested? And I think you made a comment about not having any violations, and we do have violations on record. They're older because it wasn't tested for about 10 years. But Peggy Snyder, our LSRP that we contracted for previous project on this property, she definitely, and we have the records, she definitely found violations related to the septic system in the past.
Yeah.
I'm going to object to that. I don't know if this Peggy is here or not, but we don't have an opportunity
I agree,
to
just
question her.
questions of his testimony.
Okay, so from now until when the septic is decommissioned, what is the testing that's going to be done, and is it consistent with the 94 resolution?
The septic systems were not part of my testimony tonight. I am aware that there is a septic system on the property, that there are monitoring wells associated with it. There is, like I said to Mr. Hay, there is what's called a NEJIPTES permit, or a discharge permit associated with that septic system. It is being monitored by someone other than First Environment. There is a case manager who we've spoken with, or has Royce spoken with. From my understanding, the permit is in good standing, and if there was any past violations, the department is not pressing for any further compliance or for any enforcement. So I really can't speak to the particulars in terms of the technical aspects of it, but that's what I gain or I know from working on this site, that again, it's under DEP advisement. There's a case manager, sampling is continuing, and reporting is being performed in accordance with that permit.
Okay. I think I'm done. I'll let the next
Thank you.
resident speak.
Thank you.
Run, Susan, run. I know.
I think I can adjust.
Oh.
Marmaled it.
We have a history.
All right, before,
An old friend.
Mr. O'Donnell, what is your address?
33 Ann Street. I'm right behind SW1 well.
Thank you.
Okay, Susan Gulliford, Hunt Club Road. I have a question on a...
Excuse me, Susan, what's your address?
Hunt Club. I'm sorry, Hunt Club Road.
Hunt Club Road.
Yeah.
Thank you.
And my husband grew up on Claremont, so we're familiar with the development. I have a question on one of your responses on the recent visit of a person, a surveyor. You said he was not an employee of First Environmental or your client Royce Brook. So does Toll Brothers have another employee that's researching outside of the LSRP? If so, would they report the results to you, or would they be doing this and not reporting the results to you?
Like I said before, the surveying is not part of our involvement with the environmental conditions of the 94 resolution. Our work is mainly focused here on those sample locations. So if there was you said there was a surveyor?
Well, I'm using the term surveyor. He surveyed, looked around the area. I don't know exactly what he did there.
Okay.
I don't know if he was sampling or
Okay.
doing something else.
So, sounds like you have no knowledge of a surveyor.
Yeah,
Okay.
it's basically, that's not under our advisement or under our company's.
Okay, not
protocol.
First Environmental, not Royce Brook, could be Toll Brothers, you have no knowledge of it?
No.
Okay. Briefly, those wells, the sampling, 16 residences in Claremont, were they all on Ann Street? You
No.
said they tried 19, they were able to do 16?
No, they were also on Hamilton Road.
Okay. So it wasn't over on other roads in the Claremont development further away? The proposed construction, if you look up where you have SW2,
Okay.
further up on there, yeah.
Mhm.
That's right on the edge of an application for a large construction item. Would that construction have any effect with your sampling at SW2?
I'm unaware of what construction are you,
It's right south between where you have SW2 written and the back of those houses, that nice woods in the middle, it's right there. In fact, you're right on the edge of it.
that's a little bit out of my knowledge
Okay.
for this application, but it's, thanks for bringing it to our attention. If, if we see that occurring, we'll see if it changes our results. But for now, we're mainly collecting a sample there. That's a surface water sample from that stream that connects to the millstone. We're just trying to see if there's any contribution from the golf course operation at that point.
Okay.
And again, just to go back to my testimony, note that we're only sampling for specific parameters that were outlined in the 94 resolution, and we're carrying those along. We're focusing our testing on that. So I couldn't also speak to anything else that may occur due to construction of that area.
Okay. On Ann Street, I can't remember if you or Mr. Hayes said there was no historical well testing. And my question would be, would that include a home that is being sold on Ann Street where a well test would be required as part of the sale? That you would have to look back into, or is that, again, like you said, only limited to certain things that maybe a homeowner sale would not have to do?
Well, that's a legal issue. We're under the Private Well Testing Act, which was adopted by the state in 2001, and what that means is if you have a well and you're selling your property, it has to be brought up to standard.
Speak into the mic, Mr.
And
Lynch.
show that it's fine. And Royce Brook has not received any claims of contamination of wells, even though there have been sales in the area.
So you feel if somebody sold a house, something happened,
Well, yeah,
Roycebrook would have heard about
They
it from
would
the
have been
homeowners?
notified, or the town would have been notified. Somebody would be notified.
Okay. And also, just one thing to help people looking at your exhibit, there's a large black dotted double yellow line going right through the middle of it. Could you just identify what that is? It's going right across the middle.
It's all the way to the north.
Is that right here?
Yes,
Oh, is this?
I believe that's a parcel boundary.
a parcel lot boundary. Okay, thank you.
How you doing, Mike? You- Okay, we are going to take a 10-minute recess. Boy, I can't even see what's on the clock. Yeah, we'll reconvene at 8:45 according to the clock. Okay, we've reconvened. We're in the middle of public comment.
Questions?
Questions? Yes. And you need a mic.
It's here.
There we go. Just tap it, make sure it's on.
Okay. Looks like we can you hear me?
Yep.
All right,
Okay,
good.
please state your name
Sure.
and address for the record.
Sure. Name is Tim Haracco, 3 Franklin Drive. And I have a couple different things I want to cover. Let me start with some questions about the letters that have come from...
Excuse me, sir, can
No.
you spell your last name?
Sure. Veracco, Haracco.
Thank you.
And keep the mic up to your mouth. You tend to like to move your head as you're speaking, so you
Okay.
got to speak to the mic, okay?
All right. Okay, I want to just go through the letters and a couple of questions. And I guess the preface is, in the package, there's this narrative up front that said First Environment is going to bring you guys up to date. And then it says it at the preface on the letters, too, that the letter's intent is to bring you guys up to date on what's going on. And I think it's been identified by the EC, there's some things, some comments that are misleading, and I want to just go through a little bit more of those, and then I'll give you the whole big picture. I want to go over to some of his commentary on some of the EC, their comments, and I want to compliment Mr. Hay. Thank you for backing us up, because this is all about, I'm going to come
Mr.
here to argue.
Haracco, can you ask a question?
Sure, I will.
Thank
but
you.
I'm not here to argue with you
Yeah,
guys.
no,
Okay,
we understand.
We're here to get it
Good.
right. Okay, so on the March 29 letter, at the end of, he gives a recap of the resolution, and he says, as such, conditions 8, 9, 10, and 13 were met with respect to establishing baseline conditions and showing no impact to the environment as a result of the golf course operation. Now, he clarified that it was a pretest, okay, but I guess where I go with it is, he's saying everything was met, but number one, the groundwater well was never drilled,
Right.
so that was never.
But in the form of a question to the witness.
Sure. All right, well, I guess my question is, how can you say this if the well was never drilled? We haven't seen certified lab reports for the residential testing, so it's all we saw was a certified lab report on the surface water testing. I'll repeat, nothing for residential wells, nothing. The groundwater obviously wasn't done because that well still hasn't been drilled right. So, but he makes a statement. How can you make that statement is my question. It needs to be clarified or corrected or something. It's a misstatement, misleading.
Right, and during my testimony, I clarified that comment, it was comment number 2 in the Environmental Commission's report in their memo. That basically, the samples from the potable wells were collected prior to the golf course operations, and they serve as a baseline. So the statement that was made in that report was incorrect, and just to clarify that, again, like I said, the samples were collected to establish a baseline in the potable wells in the neighboring property.
Now, you said that you were going to provide evidence to the EC on the residential testing. Does that mean certified lab reports? And if so, can we get a copy of that too? Because Township has not been able to provide any certified lab reports for the residential testing.
As part of our reports, we submit, it's a standard letter report with the results and a table showing the results that comes directly from the laboratory, and it also includes a figure showing where we collected the samples from.
I'm sorry, my question wasn't clear, I guess. I'm going
Okay.
back to the baseline testing of the 19 residences.
Okay.
You seem to say that was all done and it's
Right.
all, buttoned up, but I haven't seen any certified lab reports. I think you said you're going to give them to the township. Is that true, or did I misunderstand that?
One of the comments was Royce Brook is to obtain baseline results of residential potable wells sampled in 1996. Our response was that we have that letter report. It's dated August 8th, 1996. It's from Equal Sciences, the consultant that was performing the testing. They actually performed the testing in step with the township at the time, that we would provide a copy of that report to the Environmental Commission, and as Mr. Hay said, also should be provided to the Planning Board.
Actually, to the Planning Board and not the Environmental Commission.
Right, exactly.
gotten
We'll
that?
provide it
Have
to
you-
everybody and anybody who
We'll
wants it.
submit that.
Have you gotten that yet?
We have the report. We have the letter report.
The answer, Mr. Veraco, is the township hasn't gotten that report.
Okay, but it's on the way.
You heard what we heard.
Okay. Further on in your March 29 letter, where you talk about the DEP does not allow the 120-foot well per the regs. As Mr. Hayes said, and as my neighbor said, the DEP does make exceptions. Did you talk to the
David?
DEP? Whoops, wait a minute. This thing ran out of battery or something. It's just no more green light. Went dead.
Al Grant.
All right, back where I was, pick up where I was. You talk about, you spoke to a well driller about doing a deeper well. He said, no way. My question to you is, did you talk to the DEP?
We talked to, like I said, like you said, we talked to a licensed well driller. Those are the professionals who understand.
Trying to circumvent it slightly and anticipate Mr. Veraco's next question. The name of the well driller and with whom?
No, I don't want to know the name of the driller. with.
I do.
Oh, okay.
And it's the same point to you, Mr. Veraco. If you're going to allude to people without a name and a position, it really doesn't help the board or the transcript to use unnamed well drillers, et cetera. So, Mr. Latanzi, for
Yes.
the purposes of the record,
The
who
driller.
did your company speak to
Sure.
and when?
Sure, we spoke with Mr. Matt Lawson of Substrata Technologies. I do not have his driller's license number
When?
on me, but we spoke with him prior to the preparation of the March 29th, 2023 report, so sometime in March 2023.
Thank you.
Did we speak with the DEP? We did not speak directly with the DEP about how to install this well. We relied on our expertise in the field and as well as discussion with a licensed well driller.
Did you speak to Equal Sciences? Because they spelled it out that this is the way to go.
We did not speak with Eco Sciences.
Do you think the Equal Sciences 120-foot deep idea, as reinforced by Mr. Hay, would better be able to detect a plume in the aquifer coming from anywhere on the 435 acres versus this 35-foot hole 100 feet from the edge? I'm sorry, your 35-foot hole 100 feet from the edge of the 435 acres. Can you convince us? And that's one of the questions that, but I didn't see you answer it, that came as a follow-up from the EC.
Mr. Veraco, can you stick to one question and not multiple, please?
All right.
The question is, start with one.
Okay. Question is, I lost my train of thought.
The question is, I believe, Mr. Latanzi, can you explain why the call you're proposing is a better alternative than the one that was required as part of the resolution?
Sure, that was discussed in my testimony. Again, if you install a well as spec'd by Eco Sciences, you have to understand that you have a borehole that's open from 40 to 120 feet. And as the gentleman said before, and he's correct, this rock formation is highly fractured. Okay, so as you install a well to that depth over that length of screen, you're gonna hit multiple water-bearing fractures. That's essentially going to dilute out your sample. the purpose of the well that we installed, and this is what the DEP requires when you're investigating groundwater, is you're looking for the worst case scenario. You're looking to put a well and install it and screen it properly to capture where you would expect to find contamination. Okay, and where would that contamination be found? If we, again, what we talked about before, from top down, there are pesticides or herbicides applied to the surface. Those pesticides would then have to migrate through several feet of soil to then leach in through competent rock and then into a water-bearing fracture. As I said before, these compounds are not readily leachable into groundwater. They're immobile. So with all of that knowledge being evaluated, we thought that the well, again, screened from 15 to 35 feet, where you're assessing the first fracture you're going to encounter and sampling it, provides, a high confidence as to whether the golf course is impacting the groundwater.
Mr. Latanzi, before I turn this back over to Mr. Varacco, in which report that you provided to the board does that testimony stated?
That testimony?
The testimony you just gave. In which report will we find your conclusions that are the basis of your testimony?
I do go into it. I talk about the merits of the well that we have installed in the March 29th, 2023 report.
That's a well you installed separate and apart from the fact the requirement is for a different well.
Correct.
Thank you. Mr. Varacco?
Sure. I think, well, let me ask this question. Go back to, this well is 100 feet from the edge of the course by our homes. It had its other purpose for eco sciences, and you just sort of substituted a 35-foot well in there. It's like, to me, square peg in a round hole. Let me ask you this. The eco science thing, I'm going to ask the question, but so there's context. They talked about how it's going to give you a comprehensive look of everything that's flowing through the aquifer from across the whole course, coming into our environment, down gradient. Go back to your single hole. It's not, how do you tell us, or can you tell us how that's representative of how all the different playing surfaces, how that's representative of what could be going on at the maintenance shop on the other side where they handle all this stuff? There could be spills and leaks by the septic tanks that, I'll tell you, that I have the gypsies minor information. They're still putting out toluene as of 23.
Mr.
So,
Varacco, ask the question.
okay, question is, convince us, or how are we supposed to think of this serving the purpose of picking up on all the different activities that are going on and different exposures? This isn't even on a playing surface. This is off in the rough. You've got greens, you've got fairways, you've got tee boxes. This isn't, you got wetlands. This isn't testing any of that. It's a very singular pimple on an elephant, let's say.
Mr. Latanzi, let me go one step further. Explain to the board why they should substitute your existing well that was never approved for the well that was approved by this board 30 years ago.
Because the well we're proposing is more appropriate to determine the worst case scenario for the golf course operations. We're trying to, again, pick that location in accordance with the 94 resolution. We want to evaluate it because we consider that to be where you would expect to find in the rock.
Isn't that your job as an LSRP?
Correct. Again, we're looking to evaluate the worst case scenario. Like I said in my testimony, I understand why Eco Sciences tried to mimic the construction of the nearby potable wells. But again, it's not in accordance with regulations. And to be honest, that's not going to give you the data you need to make determinations on how the golf course is affecting the environment.
Mr. Latanzi, can you point out where, anywhere in any of the documentation you gleaned that Eco Science was mimicking the local wells for the determination of 120-foot depth?
Frank, may I have my reports? I believe that's also stated in the March 29th, 2023 letter report.
It may be stated in the report. My question to you is, where in the Eco Science report did you glean that their proposal for the 120-foot well was to mimic the local wells which is your testimony as to how eco-science came to 120 feet.
I did copy that verbatim from either the 94 resolution and/or the Eco-Sciences 1994 sampling plan.
I saw that. I can vouch to that.
It's on the March 7th,
Yes, it's on the March 7th
1994,
report.
and where it says new monitoring well, which actually is a question, says the well will be 120 feet deep and cased to 40 feet, mimicking the majority of the wells in the Claremont subdivision.
Thank you.
Can I ask you, are they casing it from the surface down to 40 feet or from 120 up to the 40 feet?
From 0 to 40 feet. So top 0, casing down to 40 feet, they use steel, okay, and that blocks off rock and soil from falling in, and they grout that into the rock. Then they go in with another bit, and they drill it down through the rock, and it just creates basically an open borehole, because it's just rock on either side.
Go on, Mr. Vaccaro.
Okay, if I proceed chronologically, can I ask a question to Mr. Linus about his letter?
No, he's not under oath.
Well, how do I ask a question about one of his letters that's in the package? Who do I ask that to?
Well, it's in the package, and while Mr. Linus marked it as A4.
A5.
A5, no, A5, thank you. Mr. Linus represented that Mr. Latanzi was going to testify as to the letter, and I don't recall any testimony. So,
Yeah, you're quite correct, Eric, but we did point out that it's all about the Private Well Testing Act, which is a law. So
I have a question about that particularly. Can I ask it?
Sure.
you can ask
Okay,
it. The question
so-
is, will somebody answer it?
Okay. I asked Mr. Linus then, he's using that as a proxy for neighborhood well testing. Did you look, my question is, did you look to see what parameters are part of that testing?
No.
Well, I did, and it does not include
Okay,
herbicides and pesticides.
Stop right there. Head.
Yep.
You got
He
the
said- he
answer
said
to the
no.
question.
All right.
Move on.
Next question.
All right, so what I want to do is say the record is wrong here. That's misleading to say
can't.
that's an
Unless you're
analogy.
gonna testify.
That comes
At the end.
At the end.
All right.
You'll get that
All
chance.
right, same thing on the letter. You said you had no knowledge of the 94 resolution until it was brought to your attention 20.
No, I said that my client.
Your client.
Yeah.
My question is, that means it didn't come up in the title search?
I believe Mr. Linus commented that, let me put it this way. I believe Mr. Linus represented, I think is the phrase I would use, that his client was unaware of the resolution when they obtained ownership of the property in 2007. Whether that's accurate is a whole different story. But
Thank
you have
you.
a representation.
Okay.
The board is not necessarily bound by the representation.
It's kind of not good to have it in here as a statement of fact when it may not be.
It's a representation, Mr. Veracco. The board is more than capable of delineating which they believe and which they will accept.
All right, getting to the June 28 letter where you say the plan closely monitors the requirements of the Hillsborough Township resolution. But then on page 2, you say, we're not going to do any more testing. How do you equate that? After 2025, you're going to say you're closely mirroring, but then you're saying, but guess what? We're going to stop after 25. How do I understand that or interpret that? It's like a total contradiction.
I believe I responded to a similar question to the gentleman from, if I hope I'm getting this address correct, 33 Ann Street, as to why we feel that that level of sampling is appropriate.
Mr. Veracco, it was asked and answered. Again, I make the point, as I have before, board is not bound by that request either.
Okay, and I'll go, and this is a little repetitive, but.
Then don't.
All right. All right, let me go to Environmental Commission. There's a series of questions after the signature page on what they published that are really some really solid questions, and they weren't answered or addressed. And I'll read a few of them off and maybe ask why they weren't addressed. One of them says...
Mr. Veraco?
Yes.
Just for the purpose of the record and sort of following up on my comment at the beginning of the meeting.
Yep.
Mr. Latanzi had the right to comment as he related to the Environmental Commission report. He will be back. And
Okay.
I would assume that when he comes back,
He'll
he
cover
will be
that.
able to, if he chooses to or can, respond to the questions at the back of the Environmental Commission report.
Okay. Thank you.
Understood, Mr. Linus?
Yes.
Thank you.
All right, I thank you.
Okay.
Mr. Chairman,
Yes, sir.
I'm having such a good time here.
You want to get up as the public?
No, I won't sit from here. It's comfortable in my... Mr. Latanzi, can you indicate where in the planning board approval between 1994 and tonight your client was authorized to dig a 35-foot well?
There is none.
So the explanation to eliminate the condition of a 120-foot well was to dig a 35-foot well that no one approved.
We could not install the well as intended in the 94 resolution.
No, that wasn't the question I asked. The question I asked is
Okay.
who authorized you or your client to put a well in that is supposedly a substitute for the 94 well without this board's approval?
There was no approval given by the board.
Thank you. Next question. What your recommendation is to the board that your client shouldn't have to dig a 120-foot well now because the DEP standards no longer allow for such. Is that correct?
To be honest, I'm not even sure if it was allowed back in 1994, but correct. It doesn't meet the current standards that the DEP
Okay.
has.
The current standards are not at issue, are they?
No.
This is a 1994 approval that your client is seeking a modification of. Is that correct?
Correct.
Therefore, the issue is not whether or not DEP would approve or disapprove this well. It's the issue of whether or not it makes more sense for this board to allow a well different than the well that was never drilled. Is that correct?
Correct.
Okay. So whether DEP approves it or doesn't approve a 120-foot well is not necessarily the issue. The issue is if it's not 120, what will DEP approve? And the board has been advised, at least at the moment, by its board engineer and its people that a 120-foot well is potentially approvable, correct?
Well,
that was his comment, was it not?
I can go back to his report, but just because you say 120-foot well, let me just go back to his report real quick.
That's the well required by the planning board in 94. That's the depth of which the board engineer in 2023 is recommending as well. So the issue is whether or not potentially DEP will permit it, and I think Mr. Hay commented on it, but that's a DEP issue and not your client nor yours, correct?
Well, correct. And also, the report says to be extended to 120 feet or installed depth of 120 feet, but it does not detail the additional specifications. Just as I spoke to the mayor before, there's different ways to install that well. We'd have to receive clarification from the township engineer as to what that means. What does 120 feet mean? Do you just want to install it from 0 to 120, or do you want to? That's the thing.
I'll ask Mr. Hay to reserve for a moment to allow me. Mr. Latanzi, you keep talking about the planning board resolution of 1994, correct? And your client seeking a modification of 4 of the conditions? How does that interact with the March 8th letter and attached plan from Ecol Sciences of 1994?
I believe we're only seeking modification and updates to 3 of the conditions.
But there's a whole separate plan submitted by Ecol Sciences a month later at the request of the planning board that they propose. What's the interaction between your client's request for modification to the February 14th, 1994 memo as it relates to the March 8th, 1994 letter from Ecol Sciences and the March 7th, 1994 plan that was attached?
Well, that plan was to support the 94 resolution as to the parameters of the sampling and the testing.
So your client is also seeking a modification of the March 7th plan to the extent it conforms with the issues in the February 14th, 1994 resolution?
Correct.
Thank you. Is there anything else that either your offices or Royce Brook has done on the site relative to the 1994 approval that's been done without this board's approval other than the well?
Not to my knowledge.
Since your client became aware and your company became aware of the 1994 resolution, according to your testimony, how many tests have been done on the site in accordance with the 1994 resolution?
To date, we've done 5 events.
That conform to the provisions of the 94 resolution?
Correct.
And the March 7th, 1994 plan?
Correct. The sampling parameters, the locations.
That includes the baseline testing of the wells at Ann Street?
That did not include, we did not do the baseline testing that was performed in 1996 by Ecol Sciences and then submitted in their August 8th, 1996 report to the township. We were not involved at that time for the potable wells.
Thank you, Mr. Chairman.
Okay, thank you.
Thank you.
Mr. Hay wants to comment, I think.
I just thought I saw someone from the public. Should be there.
Okay.
Doug Eden, 55 Ann Street. I guess I just want to ask you, you were saying that that the golf course had no knowledge of 1994 resolution upon purchasing that property. But at the time, shouldn't there have been a title search? I mean, wouldn't a resolution show up on a title search?
Only if it were recorded, and there's no evidence that the resolution was recorded.
You're
When
saying
you do a title search, they check the records as recorded. We couldn't find a deed restriction. We couldn't find a deed restriction, and if the resolution were recorded, it would have been picked up. But usually a board will say, record the resolution. In this instance, I haven't seen anything saying that the 1994 board mandated a recordation of the resolution.
Did you submit a copy of the deed?
I believe we did. If not, I have a copy with me, and we could send it in.
Okay. I guess my next question is, the water that's being pumped from the Millstone River, the Millstone River is noted to become pea soup green and turns, it has algae blooms. You're pumping the water up, you're irrigating your property. I live right on the back of the property and on Ann Street, and when you're irrigating your golf course, your greens, I could smell that water at night.
Mr. Olson, is there a question of the...
I'm leading into a question.
Please.
Thank you. So, would that water that that you're pumping and irrigating your property with, that leaches down into that SW1 and comes into our ponds. We have problems now with algae blooms also. Could that be related?
To the pumping of the water and the use of it?
Yes.
I'm not an expert on algae blooms, and my testimony didn't include an evaluation of algae blooms. Also, I'm not really well-versed in operation of, how the golf course operates. I'm just trying to evaluate the environmental conditions of, that's included in the 94 resolution.
Okay, thank you. What you were saying, that the 19 homes that were tested on, and I actually have that right here, it says sample tests. Why do you think that you're opposed to coming in and resampling those homes? Is there a reason that you don't want to come in and resample those homes for the, in the neighborhood?
That's where, you were there for the Environmental Commission meeting. We've received their comments. We've received other comments from the township. We're certainly reviewing that information and taking it under advisement.
And when are you going to let us know?
I'll have to confer with my client.
And how long would that take?
I'm sure, like Mr. Bernstein said, we'll be here for another meeting to discuss whether it's technically appropriate to move forward with that type of sampling.
It'll be addressed ultimately, Mr. Olson, when the board ultimately makes a decision.
Okay. Some of our concerns would be having our wells tested, and I think it's obvious that the 120-foot well that, that should be on that property testing our water, in my opinion. But I guess my question is, why are you opposed to not putting in the 120-foot well, since it's such a concern of the neighboring community?
I believe I've went through that in testimony. There's several lines of evidence as to why we feel that well is inappropriate. We also just responded to the public's comments about that same question. Frank, should I explain this again?
Say you answered it before.
Yes, I basically answered the same question before as to why I feel the 120-foot well with an 80-foot open borehole is inappropriate for evaluating environmental conditions, and why the well we have installed is more appropriate.
And that's your professional opinion?
It's my professional opinion, my professional judgment, yes.
But with all the concerns that we have that, don't agree with, I guess, your professional opinion.
Asked and answered, Mr. Olson. You can make the comments at the end of the hearing relative to your request for a different well, and the board will take that into account. But you're not going to get it out of Mr. Latanzi.
Okay. Thank you.
Thank you. Any other members of the public? Okay, seeing none. Mr. Hay, I know you've been jumping a bit. Do I need to close?
Yes.
Yes, okay. Motion to close public.
Second.
All in favor?
Aye.
Aye.
Mr. Hay was going to comment on something earlier.
He's about
No,
to.
he's about to. We're just closing the public portion. No worries.
Mr. Chairman, I have only one cleanup item. We didn't,
Mr. Linus, let Mr. Hay make his comments, and you can do your cleanup item, please.
Thank you, Eric.
Thanks, Mr. Chairman. I just want to make sure that the board is aware, with the role of the licensed site remediation professional. I believe within the last year, I think we had someone else that did testify who was a licensed site remediation professional in a different application. If the licensed site remediation professional decides to establish a baseline of testing, let's say in this case, 10 tests, quarterly tests, which would end in 2025, that is their purview to do. When we did do the review, we do look at the appropriateness of that, but you have to understand that the DEP gives the licensed site remediation professional the leniency to decide what that testing is going to be. Now, some of the members of the public and maybe some of the members of the board may say, well, you know, what gives them the right to do that? They do that based on what they see in the ground and what they see in the groundwater, and they take that into account when they go ahead and they come up with a testing baseline. Our licensed site remediation professionals within my own consulting firm does the same thing. So I want to make sure that there's an understanding that they have an obligation to establish this testing, and then there's reporting responsibilities after that to the DEP that they have to make. So that would also have to be put into the record, and I would ask the board make sure that that is explicitly discussed in any resolution that's passed for any amendment. Thank you.
Thank you.
However, it's still ultimately the board's it's the board's determination to grant or deny.
Correct.
Thank you.
Okay.
I think Mr. Linus.
Yes, thank you very much, Mr. Bernstein. Just to complete our record to date, we did review Ms. Bellows' report dated July 14th, 2023, and yes, she accurately points out the conditions in the 94 resolution, and her comment is, to date, the applicant has failed to be in compliance with the 1994 Surface and Groundwater Monitoring Plan, and we agree. We're not in compliance. That's why we're here. So those are our comments with respect to Ms. Bellows' report.
Okay. Thank you.
Mr. Linus, just for the purpose of the record, so we have a complete, the resolution also comes with the plan from Ecol Sciences of March 7th, 1994. Does it not?
I don't know the answer to that.
Well, hopefully you'll have the answer, whether you concur or don't, at the next meeting.
You're looking for a plan?
No, I'm looking for you to concur whether or not, when your witness talks about the resolution, that resolution also includes the March 7th, 1994 plan that was submitted.
Okay. We'll check into that.
Mr. Chairman, as I believe we discussed a while ago, this matter needs to be continued for purposes of addressing Mr. Latanzi's July 17th report, any responses that the applicant intends to do as to Mr. Hayes' report, and providing this board with updated information in accordance with that report, and also to allow the public one last chance to deal with, because I'm assuming, Mr. Linus, you're not calling anyone else?
At this point, you're correct, Mr. Bernstein. We're reserving our rights in any rebuttal situation, obviously.
And obviously, if there's going to be rebuttal testimony with a report, it needs to be in at least 10 days prior to the next hearing, and the word exhibit should not be uttered in conjunction with it. Mr. Chairman, I would also recommend that if members of the public have public record documents that they wish the board to consider as part of this situation, they also need to provide that to the board, which we will then put on Civic Clerk, provide to Mr. Linus, et cetera, at least 10 days in advance of the next hearing. And what I'm suggesting is public record document that they have. No conjecture, no unnamed third-party sources. And if they're going to submit any expert reports, and I'm anticipating Mr. Linus's objection, so I will place it on the record now, is that the individual or individuals whose reports they plan on submitting need to be here and provide testimony. Otherwise, it will be of no use to this board. And they need to be in at least 10 days in advance of the next hearing.
And the question now is,
when is the next hearing?
Because I think the calendar's pretty full already for the rest of the year.
Yep.
Could we take a 3-minute break? just to discuss
You
it.
know, I'll be generous, I'll give you 5.
5 minutes, thank you.
He's looking for batteries.
I keep telling him lithium.
Our request, by the way, is for the next available board meeting, which we think is September 7th.
Back on the record.
You're correct, September 7th, 2025. I think I can accurately, Mr. Sirachi, state for the record, there are no available meetings in September, and there are quite possibly no available meetings in October.
That's
So I'm
why we're going to
assuming
take
Mr.
5 minutes.
Mr. Coyce is going to confirm the
Right.
latter.
Mr. Coyce is going to find the next open date, and then he will confer with everybody.
We'll take 5.
So we will take 5.
Mr. Chairman, I apologize. Mr. Julian left at the break. He was not feeling well. He indicated that he will be reviewing the remainder of the video for this hearing tonight to make himself available for a vote potentially at the next hearing, which we will discuss in a moment.
Okay.
So I apologize for not putting that on.
No worries. Thank you. Okay, Mr. Coyce.
Yes, so the next available meeting we have available for this applicant is November 9th, 2023.
Which would mean that all reports have to be in no later than close of business Friday, October 27th. A couple more days than 10, just for...
We would request that there be no requirement of re-notification since the announcement is being made tonight.
This would be without
without
further notice.
Without further notice, and the meeting starts at?
7 o'clock.
7 o'clock at these facilities?
Correct.
And no need for further notice?
Right, and we need a new extension of time of decision?
I just signed one.
Okay.
So,
what's the date, David?
I have it to December 31st, 2023, signed by
Okay.
Mr. Lennis.
Okay, so...
Mr. Chairman, it's a motion to extend this hearing without further notice to Thursday, November 29th, 2023, at the Peter Biondi Memorial Municipal Building at 7 p.m. or as soon thereafter as the matter may be heard, an extension of time of decision to December 31st, 2023.
Thank you.
So moved.
Okay, and we have a second.
Who was the second?
Mr. Chiarelli.
Thank you.
Okay, thank you. Have a good evening.
Well, we
Thank you
still
so
got to
much.
vote. You got to anticipate the vote. It could be a new twist. We got a half hour still to go. So. Roll call, please.
Ms. Smith?
Yes.
Mr. Wagner?
Yes.
Mr. Radowitz?
Yes.
Mr. Chiarelli?
Yes.
Mayor Lapani?
Yes.
Chair Sirachi?
Man, you guys are no fun, yes.
There you go.
All right, now I can thank you.
There you go.
Have a good evening.
Thank you.
Thank you, everyone.
See it. Okay, with that, just a reminder, we canceled the business meeting for next week. No meetings in August, so we will see everyone again right after Labor Day, September 7th at 7
for
p.m.
Homestead Road LLC.
Right. So with that, may I have a motion to adjourn for the summer?
So moved. Second.
Okay. All in favor?
Oh,
Aye.
yeah, amen.
Okay. Everyone enjoy the rest of your summer. We'll see you in September.
Thank
Good night.
you all.